Good day and welcome to Mindful Trinity. I am your host, Vaishnavi Charan. Our special guest for today is a licensed attorney in a private practice, specializing in family and labor law. He believes life is about giving, hence he is actually on our podcast today, hoping to help all of you and to ultimately give you hope. So good day and welcome to Aslam Moola from Legal Leaders in Durban, South Africa.
Hello, Vaishnavi. Thank you for having me, and thank you for giving me the opportunity to be here today.
Yeah, like I always tell my guests, I'm very grateful that you actually you actually accepted my invite and you're here to enlighten us and give us your wisdom and your knowledge about law. It's something that we don't take very seriously because we think that we actually need to go to university to study it. But when we're going through challenges in the workplace, we need that guidance and that advice. But some of us are actually quite shy and also scared. Fear comes in the way, and that's how we actually in a blockage, and we don't know how to get out of it. But thank you so much for doing this.
No worries, Vaishnavi. And I agree with you that unfortunately in South Africa, there is an ordinary person to take on a legal matter is quite challenging because there are so many intricacies when it comes to the law. So many procedures that need to be followed, different aspects of the law, case law, statutes, documents that need to be filed. And if you don't follow the right procedures, then you can have a technical point taken against you. So I fully agree with you that in South Africa, the challenge is people have legal problems, but solving the legal problems on your own is a difficult part, and there is a need for a lawyer. But I found that the access to legal services can be quite challenging for some South Africans.
Yeah.
So hence I have developed my YouTube channel, as you've seen, and my various social media where I provide guidance to people as best as I can on their particular situation. And in today's video, what we're especially talking about is the topic of disciplinary hearings.
Yes.
And at some point, it does happen to people where you're at work and all of a sudden you get a notice to attend a disciplinary hearing. The worst thoughts are going through your mind. You're thinking, what's going to happen to me? What's going to happen to my family? How am I going to pay my bills? What are my colleagues thinking about me? I've given all these years of service to the company and now they want to dismiss me. Have they investigated this properly? And these are the kind of issues that I see in practice. So that is a scenario that does happen quite often, and that's why we're doing this podcast today to look at what people can practically do to help themselves in this situation.
Yes, thank you so much for that. But before we actually start with me actually asking you certain things and advice and all of that, I know it's your birthday today as well, so happy birthday! And I'm sure our viewers will also would like to wish you once the podcast is released. So yeah, all the best, and I hope.
Thank you.
I'm sure you're going to be enlightening more and more people because education is key, and by educating them, it'll be much more easier when they stuck in that rut for them to come out of it with your help, of course.
Correct. And obviously, not just with my help, there's plenty of attorneys out there that can provide services, and the internet is available. And also, at the very least, if people are stuck, they can approach the local courts, they can approach the local system and go to the front desk and say, I don't know what's happening. What do I need to do? There's legal aid officers. Don't let a situation fester. Don't think you don't have rights. Don't think that there's nothing you can do. There's always something you can do. And take some action. But we're going to get into all the juicy bits just now.
Yeah, exactly. So like for our audience as well, we're going to be discussing how to prepare for a disciplinary hearing, which is quite essential because all of us have faced this scenario at some time in our career. And so Aslam, could you tell us more about your organization, Legal Leaders, and what led you to become an attorney specializing in specifically family and labor law?
Sure. Vaishnavi, actually, before our podcast, I'd actually done a post on Facebook, I think 5 minutes before we started, where I was telling people that I'm quite fortunate to do what it is that I do. And I say that in the most humblest way possible because I really love what I do and I wouldn't do anything else in the world. And what do I mean by that? I actually love going and representing people. And I can't explain to you, but it's something that just calls me to do what I do. It's something inside of me that makes me come alive. That time when it's my turn to speak and everyone in the courtroom is looking at me and the judge and you can hear a pin drop silence. That is what I love. That kind of pressure moment is actually what I like to. And I can't be anything else. I wouldn't want to be a doctor. I hate being treating sores and wounds and things like that for the life of me. I don't think I can ever do that. But give me a case to work on and help me to speak on behalf of somebody. That makes me come alive. And for different people, it's different things. I mean, if you look at a guy like Cristiano Ronaldo or Virat Kohli, these are the superstars of their fields.
Yes.
That pressure moment, you need to find something when the pressure is on, you want to go forward, not go away.
Yeah.
So I had a client recently where she said she cannot do any kind of public speaking. She will give money away if she has to instead of doing public speaking. So she shouldn't necessarily be a lawyer. You know, whatever the point is, go ahead and do more of that. You know, go towards that. Don't run away from that if that is what is calling you. So in terms of what helped me to start this organization is I'm practicing law now close to 9 years. I've got my master's in law as well. And I love what I do. I've got an organization based in Durban. And that's essentially we help people in 3 areas of law: labor law, family law, and commercial law. What do I mean by that? Labor law, we talk about CCMA hearings, disciplinary hearings, labor court matters. Divorce law, access to children, maintenance, things like that, and commercial litigation is helping businesses. So essentially, to answer your question, I love what I do. I wouldn't do anything else in the world. It calls me what I do, and I started this organization to genuinely help people too, and individuals and businesses, and to give information to people so that they are empowered to help themselves.
Yes, that's actually, whilst we're actually talking, it basically told me that you found your calling. And it's very rare because not many people are fortunate enough to find their calling. And in Sanskrit, there's a word for this. It's called varna. Varna means living your purpose. Whether you get the support from people or not, you're still going to go ahead and do what you do because you love it. You've got a passion for it and it's your purpose. So yeah, you are doing that.
Correct. And it's something that you mentioned a very important point. You got to do something even if you don't get support from other people. And that's essentially the job of a lawyer. The opponent doesn't agree with you. The judge might not agree with you at the beginning of the case. If you're going to quit, you got to go ahead because you believe in the case.
Yes, of course.
So what you're saying is the core element of being a lawyer, that there's somebody opposite you who is 180 degrees to what you believe in. And then there's the judge you have to convince about your views. And he might have a different view, or she might have a different view. So having that idea to go ahead and pursue the matter, even when the world is against you, that's the core.
Yeah, absolutely. Is a disciplinary hearing, and what really happens at this hearing?
A disciplinary hearing is a good question, Vaishnavi. A disciplinary hearing is essentially where an employee is accused of a misconduct at work. So they've done something wrong, or they're accused of doing something wrong. For example, not showing up to work on time or not complying with company policy. It can be infinite number, absenteeism, dishonesty. So the company, in terms of South African law, labor law in particular, a company must have a disciplinary hearing before dismissing somebody for misconduct. You can't just fire someone.
Okay.
It's a mandatory requirement. Anytime somebody does something wrong in any workplace, doesn't matter whether you work in a fancy corporate office or you're working in a factory or a farm, the law requires before a person is dismissed for misconduct, they must have a hearing. So that is a disciplinary hearing.
Okay. So for viewers that actually have no idea what happens at a hearing, how many stages are in a disciplinary hearing or a procedure prior to going for the disciplinary hearing? Are there any sort of stages that people have to follow or the law follows?
Yes, absolutely. There are a few stages that are important, but the law also tries to make it as simple as possible for businesses to follow. So the essence of a disciplinary hearing, think about it like a meeting. It's a structured meeting. Somebody speaks, somebody listens, somebody speaks, somebody listens. So for example, at a disciplinary hearing, the first person to speak will be the company. So the company will have a representative. There'll be three parties present. Let me start off there. There'll be a chairperson, which is a judge. There'll be the company representative and the employee, or the employee representative if it is allowed in company policy. So there's three people there. Both people talk to the chairperson. Now, who starts is the company. The company, in terms of the law, has to prove their case. It's not for the employee to prove his innocence. It's for the company to prove his case. So, in essence, what will happen is the company will start with an opening statement. Then the employee will reply with an opening statement. Before that, the chairperson will ask, are you guilty, not guilty? Most employees plead not guilty because they're innocent of the charges. Then company does opening statement. Employee does the opening statement. Company leads their evidence. Then the employee will lead their evidence. And then it's closing statements. It's a very simple process. Okay. The whole gist of it is both parties must have a fair opportunity to speak and interrogate the evidence. Now, you might be thinking, this is so formalistic and it's so out of this world. But I see clients on a daily basis that sit in this office chair and they are crying because they're being dismissed from work. These are real issues that people don't talk about.
Yes.
And they're embarrassed to say they've got fired. Nobody wants to go and tell their family members, colleagues. I had a guy who didn't tell his wife for 2 months. He used to pretend going to work because he just didn't know what to tell his wife. So these are things that you might think, hey, Aslam's talking about some legal textbook stuff, but people need to know this. They need to know what the procedure is. And that's essential to disciplinary procedure.
Okay. So how should one prepare for a disciplinary hearing?
Oh, that's a good question. And it is a bit of a tricky question because it involves each person can only prepare to their capacity.
Okay.
But actually, what do I mean by that? I mean that you can't expect a 60-year-old person to go and collate emails and documents if they're not tech savvy. But here are some basic principles that a person can use. The basic principles. The first thing you need to do is write down, take out a piece of paper, an A4 piece of paper, and make 2 columns. On the left-hand side, you either write guilty or not guilty. On the right-hand side, you list all the charges against you. So whatever the charges are, so let me start off. Before you have the hearing, the company will give you a notice to attend the hearing. That must be done at least 2 days before the hearing, 48 hours. That's what the law says, minimum. You must have time to prepare. You take that charge sheet and you look at it and you say, am I guilty or not guilty? And if you're guilty and you know you're guilty, then you go and admit your guilt.
Okay.
If you're not guilty, you write not guilty next to each charge. So that's the first. The first kind of guiding point is either you're guilty or you're not guilty, decide up front. And you're going to make this decision based on the evidence that you know and also based on whether you did it or not.
Yeah.
I mean, if you know you sexually harassed somebody, don't write not guilty. If you did something wrong, you need to own up to it. Or if, on the other hand, if the company, I've got an employee who was accused of stealing something, and yet there's tons of evidence to show that she did not do it. And there's a personal motive in the company against her. So then she should write not guilty. You know, she has the evidence to back it up. So starting point is write guilty or not guilty. Second thing to work at is now look at what evidence the company has against you. In your mind, you need to think, are they going to call witnesses? Are they going to use documents? How are they going to lead their case against you? Start planning that. Start to think what can be used against you and start to plan how you're going to respond to it. Because the company starts.
Okay.
You see?
Okay.
So you need to have responses to their witnesses or their documents before you even get to your turn.
Okay.
So I'm giving you a streamlined process.
Okay. So in terms of, okay, for example, it's theft. Will you actually get the notification for you to actually attend the disciplinary hearing, or is there something like a written warning, a verbal warning before it gets to that stage?
That's another good question, because a lot of people come with the idea that you must get a warning first before you get dismissed. Yeah. And the law essentially on that is you can only get dismissed for serious offenses, serious forms of misconduct. That's what the Code of Good Practice says. Now, what are serious forms of misconduct? Dishonesty in any form. Even if you stole a box of chocolates, it's dishonest. Any form of dishonesty justifies dismissal. Number two is serious forms of harassment, sexual harassment, and serious forms of incidences where the employment relationship is broken down. So, to answer your question, you don't have to get a warning if the offense is so serious that it justifies a dismissal on the first offense.
Okay.
So, for example, if you committed sexual harassment, you can't go and say, I want a warning. You have to be dismissed. But if you were late by 6 minutes, it doesn't really justify dismissal. Maybe you were running late, maybe you woke up late. It happens, all human beings.
Yeah.
So that would justify a warning. And that's where you find a lot of conflict between employers and employees. They say, I should have gotten a warning. Other people say you should have been dismissed. That's why we have the CCMA and the Labour Court.
Okay.
These are independent bodies that check, was the dismissal right or wrong?
Okay. With regards to the CCMA, are they actually for the employee or the employer?
Another really good question. It's not for the employees or the employer. There's a huge misunderstanding out there that the CCMA is there to protect employees. It's not. And it's neither there to protect employers. The CCMA is a body created by the Labour Relations Act and government, in essence, where it is meant to be a neutral umpire to hear both sides and make a ruling. So it's not there to protect any party. Okay.
Very interesting. What type of questions are asked at this hearing? Just to get our viewers, to prepare themselves if they're experiencing something like that.
It depends on what offense that they're being charged with. So questions for dishonesty would be very different to questions for sexual harassment or any kind of thing. But the questions will depend often on the evidence also, if it's documentary evidence or witnesses. Now, I would presume you're asking me about cross-examination questions or questions to for your testimony.
Yeah, well, in fact, just to get them, some people actually haven't experienced this in their life. In the career I'm talking about, they never ever experienced something like this. So, especially for someone that actually just started working in the corporate world, or well, actually working in general, and they get
Yeah.
invited for a disciplinary hearing for maybe, yes, like coming in late, 6 minutes, maybe even 10 minutes late, and maybe they didn't have airtime, so they could not call their boss and to let them know that I'm actually running a bit late. Maybe they got financial difficulties, even though they're working, but they actually have to support a family or whatever, so just trying to give them ideas how to prepare themselves if they were invited for a disciplinary.
Yes, in that particular situation, what you would do, Vaishnavi, is you would focus on the lack of the seriousness of the offense, but the kind of questions you would ask depend on, like I said, the offense. So using your example of late coming, generally you get a warning for that. I think based in practice, what I see often is failure to comply with company policy and procedure. That's the most common form of dismissal that I see. And that's you basically the type of questions you would ask. Where's the company policy and procedure? When did you give me training on this? Is it a dismissible offense on the first time? Shouldn't you be giving me a warning for this year? What are my rights in terms of labor law? You should ask the company all of this.
Okay.
Do I have access to a trade union representative who can assist me? These are the kind of questions you would ask.
Okay. What is a reasonable time to prepare for a disciplinary hearing?
The law says 48 hours, but I think when I get employees calling me 2:30 in the morning, and not that I take their calls, and I don't encourage anyone to phone me at that hour, but I see missed calls and things like that. It's a very stressful time in a person's life. They're not thinking straight.
Yes.
They're very emotional. 48 hours isn't enough time, in my opinion. And I'm just a labor practitioner, and I genuinely believe that employees should have a minimum of 3 days, not 2 days.
Okay.
3 days should be sufficient, although it all depends on the facts of the situation. So if you got one charge, or one or two charges, and it's very straightforward stuff where you know you've committed it, then why should the company wait 3 days? Because just like how the employee needs to resolve the issue, so does the company. Remember, the company is not in the business of having disciplinary hearings. They're in the business of selling tiles or rendering services. Now you're taking away company resources to attend to this, and if they don't attend to this, the complainant who had a complaint against you will have a problem against the company.
Okay.
So we can't have 5 days and 1 week and 2 weeks. It impacts on the main business of the employer, which comes back to my original point. Labor law is to help the employer and the employee. It can't be too onerous on either party. Otherwise, they won't comply.
Yeah, of course. So I'm going to give you two scenarios. One, what happens if the defendant refuses to attend the disciplinary hearing? And you can actually just maybe guide me with that. And then the other is, what happens if the company representative does not attend the hearing for whatever reason?
Okay, so now we're talking about disciplinary hearings.
Yeah.
I think maybe in the future we can do one on CCMA hearings, which I think people need to know as well. That is what we need to do in order to prepare. So there's 2 stages. The disciplinary hearing stage is what we're talking about. It's still internal, you still have a job, you haven't been fired yet. And then if you have been fired, what do you need to do after that? That's a whole separate video altogether. It's a whole separate issue.
Okay.
Now, you said if the company doesn't show up to the disciplinary hearing, the charges are dropped because they're not there.
Okay.
If the employee doesn't show up to the disciplinary hearing, and often this happens, they just bury their head in the sand thinking it's going to go away. It doesn't. You'll get fired in your absence.
Okay.
You have the company, even if you go to the CCMA, the company will just say, we tried to have a hearing, we gave him notice, he never pitched up. And the CCMA, like I said, is an umpire. Look at both sides and say, why didn't you come? No, I was sick. Did you give them a sick note? No, I didn't. I'm sorry, you can't just, it's unfair to the company, you
Yes.
know. So labor law is for both sides, and employees need to understand you can't get away with not doing your part of it.
True, very true. Very good question I've got for you. Well, I'm actually very curious as well. I'm sure whoever is going through this at the moment, they would also want to know and take your advice. Do you have any tips for anyone that's going through something stressful at the moment to remain calm during the hearing or even before, when the preparation stages and all of that?
Yes, I do, and many tips that I practically use myself during hearings at the CCMA, even at the labor court when I'm arguing before judges. The most important thing is the mindset. What do I mean by that? You must believe in your case before you go into the hearing. If you have any doubts about your own case, it's going to come across in your body language, in your tone of voice, in how you conduct yourself. Your shoulders will be drooped over. You just wouldn't be open and expressive. So the first important tip is believe in your case. Number two is prepare. You must prepare. To get to the self-belief, you must be prepared. That means you must know what your opponent is going to be talking about, what evidence they're going to be reading, what documents they're going to call, what are you going to do to rebut that. Your confidence comes from preparation. And you asked me what my motto is. That, now that I think about it, is my motto. And I wish I had that. Is your confidence comes from your preparation. I always believe spend more hours preparing. I think it was Abraham Lincoln. I stand to be correct. He said if he had 10 hours to cut down a tree, he'd spend about 8 hours sharpening the axe.
Wow.
So that he'd only spend a very little time cutting down the tree. So in the same way, spend a lot of time preparing for your case. Going through case law. If you don't know where to find case law, go into Google and type in SAFLI, SAFLII, SAFLII. It gives you free case law. So these are things you can do. Read cases. Go to pro bono. I don't offer pro bono services because I also have a business to run. But if you need pro bono and you can't afford a lawyer at all, then go to pro bono. Most courts offer pro bono services. Take steps to help yourself. Don't just sit back and expect the universe to help you. It doesn't work.
Exactly.
You'll be really disappointed.
Yeah, that's very true. It's like sowing a seed. What you put in, that's the results you're gonna be seeing anyway. And
true, absolutely.
You know what? But when you were talking right now, I was actually thinking about your logo, about the lion actually roaring, and that's powerful. And I think, if anyone, by seeing that, they would want to actually, put their trust in you to actually help them. And because a lot of people are looking for people to trust in order to help, they don't know who to actually go to. And I know I'm actually deviating from what we were talking about, but
no, it's an interesting story about the lion. My what do you call him? My office manager. His name is Doug. He decided to go with that approach, and he put the project together. And he said, "Hey, Aslam, I think you should go ahead with this line." And I said, "Come on, Doug. It looks so unprofessional. It's not who I am. I don't want a line rolling in the background." And he said, "No, I like it." We had a team vote and all decided, so it was against me. But it apparently is quite popular. But for me, the whole idea is, regardless of what logo and entrance you have, you still have to deliver the goods, and you still have to be prepared. You can have all the best companies in the world. They can have the best logos and everything, but they deliver. It's not your logo that wins your cases. It's who you are in your preparation. In the same way, to apply this to viewers, it doesn't matter how pretty or ugly you are. You can be the most gorgeous person in the room, or in society's words, the most unattractive person. But it all comes down to the evidence cases. It doesn't come down to how you look or how the logo looks, whatever it is. Or even how well dressed I am. Yes, impressions are important. Go
course,
there with your
yes.
best. I'm not saying go in your beach shorts with CCMA or
Mm,
to the hearing. Go in your best clothes and make you feel confident. That's
yes.
the whole thing.
Yep.
And then go and put your best foot forward.
That's so true. Um, is the company allowed to dismiss or discipline someone if they are going through some sort of mental issues, such as anxiety, depression, or even stress?
You know, Vaishnavi, that is so current today.
Mm,
And I think one day we need to do a session on that where we just cover mental health in the workplace, labor law. We
okay.
should do that.
Okay.
And because there's so much of case law on that point,
Mm-hmm.
there's a recent judgment where a lawyer actually was working for legal aid.
Yeah.
And it's a reported judgment, so I can share it.
Yes.
And one of the paragraphs in that judgment where the judge said, there is a duty on employers. This is off the top of my head. I remember reading that case where the judge said it's a duty on employers to accommodate employees with depression. Now, the fact that the judge said that, and maybe as a non-lawyer, you don't understand the importance of that, but how is South African law made? South African law is made either by Parliament when they pass a statute like the Labour Relations Act, or it's made by a judge in a court by giving a judgment. So, for example, the topic of recent interest is restraint of trade. I did it with 5FM recently, where restraint of trade is where you sign an employment contract, and in your contract it says you can't work for somebody else for a certain number of months or years or whatever it is.
Yes.
And that used to be the strong provision in our law until recently, where it went before a judge in the High Court, and the judge in the High Court, no, I'm sorry, now it's COVID times. People need to earn a living. You can't stop this man and make him sit at home because of a restraint of trade.
True.
So he said special circumstances,
Mm-hmm.
which allow for special situations. And whoever's interested, I can send them a copy of the judgment. Contact Vaishnavi, will organize it for you.
Okay.
But that is an example where the law is developed by a judgment. Now the law on restraint of trade is moved forward by this judgment. So coming back to the original point, the judge in that case said it is a duty on employees to accommodate employees with depression. The law moved forward on mental health in the workplace. Do you see?
Yeah. So does it depend on the judge that you have at your case in order to get the outcome of that case?
Yes and no.
Okay.
Judges are appointed to positions after stringent checks and balances.
Okay.
And they often are people of the highest caliber.
Okay.
A judge, to be appointed a judge, there's a very strict process, very strict interview. There's a complete background check, etc. So for a judge to be a judge, there is a strict process. Okay. Having said that, the individualism of a judge will come out in their own judgment. So there's certain aspects that make a judge human, and those are the aspects that they will bring out in their own judgment. But generally, there's objectivity in the law. Generally, there is fairness in the law, and that's why we have the rule of law in South Africa. It is something that is really something to be proud of. We have former presidents being sent for hearings and things like that to be current about issues. So the rule of law is quite strong in our country.
Okay, awesome. You know what? I actually work with a lot of people with mental challenges in a sense where they're stressed and depressed, especially during this old COVID pandemic. A lot of people were actually living in their heads, and all of us have faced it at some point in our lives because we were actually confined to our homes within this four walls, and the only people that we're actually associating it with is actually with people that living in our homes, if we are lucky enough, because not everyone actually have that. Some people are living on their own. And that is why I also said I wanted to help people with mental challenges with regards to like stress in the corporate world. And that is why I'm actually helping them. And when you actually said we should do another show about that, I think that'll be very, very nice because people need it. Yeah.
It's a highly relevant topic, and maybe in that we can do working from home,
Yeah.
mental health at the workplace, labor law,
Mm.
and how to manage working from home labor law.
Okay.
Combine it into one. That will be a highly current topic to look at.
Yeah. Yeah.
And I think a lot of people would be interested to know that.
That's so true. So to our viewers, just stay tuned. You are going to be getting more from Aslam and I.
And send us questions. Send us what you want to know. Maybe that's what we think, but tell us what you want to talk about. I mean, we have a platform here. Send us some questions.
Exactly. And I do agree. I think without the questions from our audience, it'll be difficult for us to serve them in the best of our capacity. So yeah.
Sure.
Okay, before we actually go further, I want to just ask you, how many warnings does one get before the actual disciplinary?
It all depends on the offense. Minor offenses should be 1, 2 warnings, like for instance, absenteeism, depending on how serious it is, how serious that person's position is in the organization. For example, the CEO, if he's absent for 3 weeks, it's serious to the organization, versus somebody who's like in a telecall center and there are 12 people in the team and someone's away for 2 weeks. It's impact on the business, but I mean, it's not like major where the business is collapsing.
Sure.
But it all depends on this. The labor law is a very situational dependent. We can't say this must be our final warning. It all depends on the situation, impact to the company, things like that.
Okay, makes sense. And does a disciplinary go on your reference?
No, not on your reference.
Okay.
But if you dismiss, it goes. If you are dismissed, it goes on your record at the Department of Labor, dismissal, and you have to challenge it. Otherwise, it will be on your record forever.
Wow. Okay. So, what advice? Sorry, go ahead.
Not a lot of people know that it's on your record. You must challenge it.
Okay. That's actually.
And you challenge it by going to CCMA.
No, go ahead. Both of us are getting excited at the same time.
Yes, you challenge it by going to the CCMA. That's how you challenge it.
Okay. Yeah, but
it's a free process to go to CCMA. You don't pay to have a key to CCMA.
But with regards to CCMA, doesn't the process actually take quite long? Sometimes a year, even more?
No, they've streamlined it quite a bit now. It's well, due to COVID, there's a lot of cases, right? So don't expect immediate time frames. But it all depends on the CCMA you act. For instance, if you're in a major town like Joburg, Durban, where there's lots of cases, then if you're outlying areas, etc., depends on the volume, but generally between 8 to 12 weeks is the expected time. So about 3 months.
Okay, awesome. What advice would you give those that are going through either disciplinary or challenges at work that are making their lives very uncomfortable?
Well, the most important advice, I think, is something that most people should take heed of in any event, is to always get things in writing. Always get things in writing. Make sure you have a written document. Now, if the company won't give it to you or you had a verbal discussion, send an email, send a WhatsApp. Hi, John. I referred to our chat earlier, wherein we said A, B, and Z. Thank you. Send a short record of that discussion, because oftentimes at a later stage, that discussion is very important. When you got permission. So for instance, I had a case recently, last week, in fact, where an employee was accused of using a company vehicle for her own purpose. I won't mention names, actually. It's attorney-client confidentiality. And the case is pending. But, and I said to her, where's our evidence? And she said it was a verbal discussion that her line manager came. He's going to change the story because he has a job to keep.
Of course, yes.
You should have said same time, sent an email or WhatsApp. Hi, Mr. X, Y, and Z. Thank you for letting me keep the company car. I have to return my rest. Cheers. And if he doesn't reply, too bad, he's got it. The fact that he doesn't reply means he's acknowledged. It's even better. So the most important tip, and my final tip is, get things in writing, never leave it to chance.
Absolutely perfect. I mean, awesome advice. And I think all of us need to actually get into that habit of putting everything in writing to protect yourselves as well, you know?
It is. And it doesn't take a lot of time. It's 30 seconds of just sending a WhatsApp.
Yeah,
If you
true.
don't want to send an email, send a WhatsApp. Everyone's on WhatsApp today. And you screenshot that to use as evidence if you have to at a later stage.
Yes, very true. So, Aslam, how can our audience find you on social media or even actually in the real world?
Well, the quickest way to find me is on Facebook or YouTube, and I have access to the Facebook account directly. So if you just type in Aslam Moola, ASLAM, MOOLLA, that's my full name, and you'll see my picture come up. Send me a message, I'll probably reply. So that's one way to reach me. The other way is just check on YouTube if you don't want to talk to me. In fact, a lot of people don't talk to me. And the other day, a bunch of people, CCMA, I met a guy there and he said, I saw your videos and I clipped and I'm here. So if you don't want to talk to me, then just go into YouTube and type in Aslam Moola lawyer. You'll see a whole bunch of videos there that you can use to help yourself. And you never have to speak to me or even pay me for that.
Okay. Thank you so much. It's been such a pleasure and actually an honor to speak with you today. It was so
no problem.
Yeah, it was actually so enlightening for me, and I'm sure my audience, once they actually listen to this, they'll be very grateful, like I am. So thank you once again, and enjoy the rest of your birthday, and all the best.
Thank you so much, Vaishnavi, and it's been my pleasure. It's been my pleasure to be here.
Okay, thanks again. Bye-bye. So bye to our audience. Okay.
Bye.
Bye-bye. To Mindful Trinity viewers, and hopefully you found this very, very informative. I actually enjoyed speaking to Aslam Moola on this subject. On this topic was something that all of us actually need. So if you have any questions for Aslam, you can actually either send it to me or you can actually get in contact with him. You know his details, and I will actually put it onto the comments feed. Thank you once again. Bye-bye. Have an awesome day.